All right, well, we're going to go ahead and get started. Good morning. I am Brandy McAfee. For those who don't know me, I am part of our administrative team and coordinate our marketing here at Dale, Huffman, and Babcock. Thank you for taking time this morning to join us for estate administration and probate. Our presentation today is being recorded for future use. We encourage questions. Please use the chat feature at the top right corner. We will be opening the mic and answering all of our questions at the end of the presentation today. Today's speaker is our firm partner, Timothy Babcock, and Senior Associate Kristen Steckman-Kalinsky. I'll now hand it over to Kristen to get us started.
Great. All right, thanks, Brandy. Hi, everybody. We're going to get started today. We're going to talk about estate administration and probate, so the processes that we follow when someone passes away, administering their assets, and hopefully demystify just a little bit what probate actually is. Everyone's heard the word, not a lot of people know what it actually is. So we're going to talk about all of that. Clicker's not working. Hold on just a second, please.
Hang on, we're having some technical issues. Hold on.
We're good. Okay. So just so we know, the information that we'll be giving today is general information. We're not creating any sort of attorney-client privilege. So we just have to give that disclaimer because lawyers love disclaimers. It's what we do. So with that, we can get. Are you doing that or am I doing that?
That's me.
Oh, okay. I thought I was doing it. All right. Anyway, sorry. We'll figure it out here. As Brandy said, my name is Kristen Kalinsky. I'm a senior associate here at Dale, Huffman, and Babcock. I have been practicing in the area of estate planning and estate administration since 2007. And with me,
Tim Babcock. I'm a partner here at the law firm, and I have been doing this for 22 years now. So and the majority of my practice is going to focus on estate planning, estate administration, elder law issues.
Okay, so our goal is to give you as professionals kind of an idea of how to discuss these issues with your client and how to give your client some sort of practical advice. When someone passes away, obviously it's a very stressful time and people tend to get a little lost in terms of what they need to do and when it needs to happen. So as a preliminary matter, we get the question all the time, when should we call? Someone has died, when should we call? And I usually tell my clients in almost all circumstances, there's no need for us to be the first people you call. I've had people call me the same day that their loved one passes away. And I tell them, deal with the family stuff, deal with the funeral. Those things are more important and should be the priority. And then once that dust has settled a bit, a week later or so, give us a call. So we'll schedule that first meeting and we'll get the administration process started. So next slide. So the first thing when clients come in, to the extent for that first meeting, to the extent that they can have a list of assets of the deceased person compiled, that helps us get started. Of course, they're not going to have all the information and there's no need to have that complete and total list. But the more information they come in with, the better advice we can give them right out of the gate. The first question that usually we face is whether or not we're going to have to open a probate administration. And so we have to talk a little bit about what assets are probate assets and what assets are non-probate assets. So probate assets are subject to the will and go through the probate process with the court. And these are really simply assets that have two characteristics. They are in the deceased person's individual name, and they don't have a beneficiary designation, like a beneficiary designation you'd see on a life insurance policy, for example. So pretty much everything else is non-probate, and that's a broad swath of property. Non-probate assets include anything that's held in a trust, anything that's owned jointly with another person, anything that has a transfer on death or a pay on death designation, or anything that has a beneficiary designation. So life insurance, retirement accounts, pensions, annuities, all of those fall into that beneficiary designated asset bucket. So a lot of assets aren't subject to the probate process to begin with. So that's why I say, to the extent we can start that first meeting with whatever assets we know are out there, it gives us as attorneys a sense of kind of what direction we're going to have to go. I'm going to go to the next slide. So you might have a patchwork of different kinds of assets. And so you might be doing different types of administration. You may be running along 3 parallel paths, administering different assets in different ways, depending on how they're titled and things like that. If assets are owned in a trust, the trustee is going to follow the terms of the trust and distribute them as the trust directs. A trust is not typically filed with the court. It's not subject to the probate process. So the trustee's just gonna follow the terms of that instrument. If an asset is jointly owned, for real estate, nothing has to be done. There's no need to record anything to indicate that a joint owner has died. The tax bills will continue to come in both owners' names, but that's not a legal problem. So there's really nothing that has to be done. Bank and financial accounts that are joint, the surviving joint owner just shows up with a death certificate, and the bank will take the deceased person's name off the account. When something is transfer on death or pay on death, there's a couple of steps you might have to take. If there's a transfer on death deed on file with respect to a piece of real estate, you have to record a subsequent, what we call survivorship affidavit. It's a 1 or 2 page piece of paper that we prepare that basically just informs the chain of title that the original owners passed away and that now the TOD beneficiary owns the property. For TOD accounts that are at a bank, you just, again, present the death certificate. The bank will issue a check or retitle the account in the beneficiary's name. For beneficiary designated assets like life insurance and retirement accounts, you typically start by submitting the death certificate to the relevant financial company. They'll then send a claims packet and the beneficiary or beneficiaries will fill them out. If there are 3 beneficiaries of the account, the company will send out 3 claims packets, 1 to each of them typically. Usually our clients can handle that part of the process on their own. I'm always happy to sit down with a client if they're struggling with the paperwork and not understanding it. But usually they can handle that on their own. And if they've got a financial planner in the picture, that's always very helpful so that they can understand. With qualified retirement accounts, obviously there are a lot of questions about deferral, and it's helpful if they have a financial planner who can help walk them through those options. I'm just going to go to the next slide. So real estate is kind of a unique animal. If you're talking about someone who the only asset was real estate, I'm getting ahead of myself, I'm sorry. So as I mentioned on the previous slide, if you've got transfer on death real estate, it's a very simple process. It doesn't go through probate, you just record that survivorship affidavit. If it's a case of a married couple that owns real property jointly, nothing is required. The ownership continues joint, and you don't have to do anything. Every once in a while, a surviving spouse, it will be emotionally difficult for them to see their deceased spouse's name continue to be on the tax bills. In that case, you can record an affidavit of death of the deceased spouse and have the tax bills reissued in just the sole name of the surviving spouse. But typically we don't have to do that. It's only if they want to do that, and we don't do it often. And then there's a really strange rule. If someone dies and the literal only asset they have is a piece of real estate, regardless of its value, you can wait 5 months and use a title transfer affidavit, and you don't have to go through the probate process. Actually, it says it's a 5-month rule, and that's accurate. But there's a strange quirk of the law that a title company, you can sign a title transfer affidavit after 5 months, but a title company won't insure title until 7 months. So it's really a 5 or 7 month rule, depending on what you're trying to accomplish. But if literally the only asset is real estate, you're not going to have to go through the probate process. You can use a title transfer affidavit, which is a much simpler way to transfer real estate. If you've got other assets, though, that's probably going to make that impossible. However, if the total amount of probate assets, including real estate, is $50,000 or less, then there's a summary, or there's a shortcut we can follow. And that $50,000, you start with the $50,000 of non-probate assets. You subtract off any liens and encumbrances. So if there's real property that's, it could be a valuable piece of property, but if there's not a lot of equity there, if you subtract off the mortgage, if you're not left with a lot of equity, you may come in under that $50,000 threshold. You can also reduce that 50,000 or deduct from that 50,000 reasonable funeral expenses. So those are things you got to look at when you're determining whether or not you meet the probate threshold in Indiana. But if the total amount of probate assets are under that probate threshold, you don't have to open probate with the court and go through the complications of that. We can use what's called a small estate affidavit. And it's a 1 or 2 page piece of paper. It sets out what the assets are and who's entitled to them. And you can take that to the bank or the financial company or wherever it needs to go and transfer assets using the small estate affidavit. There was something I was going to mention about the probate threshold and I forgot. I don't know.
Sorry.
If I remember, I will come back to it.
Hop right in.
Hop right in, yeah. So, okay, so I guess with that, I'm gonna kick it over to Tim.
You know, we'll try. We'll make
Try
one
again.
last college try
We'll make it.
with our clicker here.
An
I
attempt
don't
to
know how
use
that's
the
going to go. And it's still not working. That's okay. That's just fine. All right. So, you know, Kristen had mentioned the $50,000 threshold limitation for probate. So if you are over the $50,000, does that mean this is what you are ultimately going to face in the process of probate? And no, it isn't. So there are a lot of myths out there about probate, and Kristen's going to touch on a lot of those. But what I want to do next is talk about probate. So what exactly is probate? You hear that term tossed around all the time. And I really used to struggle to come up with an explanation for what probate was and why we needed it. But I heard a presentation given by our probate magistrate in Allen County, Magistrate Howe. And what he said was, probate provides answers in a time of chaos. And what do I mean by that? Well, I feel like this is best illustrated with an example. So let's suppose that my wife had passed away before I did, and then I subsequently passed away. My oldest son goes down to the bank and he tells them, my dad has passed away, you need to give me all the money that he's got in his bank account. Well, first of all, how does the bank know that he's the one that's going to be the one receiving it to make distributions? Number two, how does the bank know he's the one that's really entitled to it? Maybe I wanted to leave my assets to my younger son or to a charity or something along those lines. So that's what probate is ultimately going to do. It's going to tell us 2 things. Number 1, who's in charge of our estate? And number 2, where does the money go? And in essence, that is what we are accomplishing with probate. Now, if you've got a will, as shown there on the left, then the will is going to answer both of those questions for you in a very easy manner. If you don't have a will, then there are answers to those questions, but they're a little bit more complicated. So as to question number 1, who's in charge if there is no will? Well, Indiana law sets forth a priority of who is able to act. And that's going to start out with a spouse or a person nominated by a spouse. It's going to be an heir or a person nominated by an heir. And it's important to note that within those classes, so even though the spouse is above an heir, there is no priority amongst anybody in a particular class that's able to act. So interestingly enough, case of mine that is actually wrapping up right now, the individual passed away with no will, so we were operating under the laws of intestacy. And I'd been involved with this family before on the other side as a beneficiary. I thought to myself, there's no way in the world I don't want to be in charge of the next estate. So got together with one of the heirs of the estate, put together the paperwork, and at the time my assistant took the paperwork home with her. She lived close to the courthouse in the county where the estate was going to be administered. She went in as soon as the courthouse opened, filed the paperwork, and was able to get my client appointed as the personal representative. And as she was walking out of the courthouse, the other attorney was walking in. So we literally won the race to the courthouse. Which is rendered a little bit moot now with the fact that we have electronic filing, but it's still important to note that if you are in an intestacy situation, you really do want to try to get your paperwork on file as quickly as possible. So let's then look at question number 2, who gets your stuff? And again, we're not worried about that with a will, but more so if we don't have a will in place. So off the bat, the first $25,000 of assets in an estate are going to go to a surviving spouse if there is one, or that $25,000 is going to be split among minor children. So from there, again, Indiana law does provide where your assets are going to go. But the results that you get under Indiana law may be a little bit surprising to you. For example, if you pass away, you have individually owned assets, you're survived by a spouse and children of that marriage, everything is not going to go to your spouse. In fact, that property is going to go half to your spouse, half to your children. It's an even quirkier result if you're survived by a spouse but don't have children. In that circumstance, your spouse gets 3/4 of your estate and your parents divide the other quarter, which is just completely bizarre to me. And if you're in a second marriage situation or subsequent marriage situation, and there are no children of that marriage, it becomes practically unworkable. So in that particular situation, half of your personal property is going to go to the surviving spouse. And I don't necessarily mean tangible items, but your bank accounts, things like that, are going to go to your surviving spouse. In addition, that surviving spouse is entitled to 25% of the value of your real estate. And I'm not sure how you accomplish that without there needing to be some sort of sale in place. And it's important to note for the laws of intestacy, again, if there is no will, that if you've left other assets to your spouse, say in a joint ownership or in a beneficiary designation, you don't get credit for that. So that doesn't count against what the surviving spouse ultimately gets. So if for no other reason than the quirky results under the laws of intestacy, you really do want to have a will so that you know exactly what you're going to end up with at the end of the day. So if we've decided that we do need to go ahead and have an estate, our next consideration is going to be what type of administration is it going to be? And what we've got here in Indiana is a supervised versus an unsupervised administration. And I like this illustration because in a supervised estate, as you've got there in the picture on the left, it's very rigid, everything is very orderly. In an unsupervised administration, it is a little bit like children frolicking in the meadow someplace. So if you've got a supervised estate, it's important to know that unless the will gives you broad authority, basically everything that you're going to want to do as the executor, you're going to have to get court approval for. You're going to have to file a petition with the court. Court is going to have to set that petition for hearing, offer the beneficiaries of the estate an opportunity to object. So it's going to become very time consuming, it's going to be very labor intensive, and it's going to be a lot more expensive when it comes time to do anything that you want to do with respect to a supervised estate. So in addition, when it comes time to want to close out a supervised estate, you have to prepare a full-blown accounting. That accounting gets filed with the court. Again, court is going to set that for hearing. That accounting is going to become a matter of public record. So any nosy person can get in and see what all comprise that estate and where those assets are going to go. So again, supervised estates are generally not a desirable way of handling an estate administration. Contrast that with an unsupervised administration. So the court involvement in an unsupervised administration is very minimal. The court has a say in who's appointed to be in charge of the estate, but that really kind of ends the involvement that the court has at that point. Under the probate code, the personal representative has very broad authority and very broad powers to be able to act. When it comes time to close out an unsupervised administration, you file a basic informational document saying that you're closing out the estate. You provide that to the beneficiaries. You are obligated to provide an accounting to the beneficiaries, but that accounting never gets filed with the court. It's going to remain private. So for the vast majority of estates that we handle in our office, we always want to take a look at doing it in an unsupervised capacity. Now, of course, there are exceptions to that rule. So if you have an estate where the beneficiaries absolutely hate each other, they hate the personal representative, it may make sense to go ahead and have supervised administration so that there is a resolution to any sort of issues that are out there. Also important to note too, that if you're in a situation where there are less asset, or where there's more debt than there are assets, you can't have an unsupervised administration. You do have to proceed supervised at that point. What does the probate process look like? So the attorney's office is going to go ahead, they're going to put paperwork together that the personal representative is going to sign, and they're going to submit that to the court for approval. After approval has been given to the personal representative, again, if we're in an unsupervised estate, then the executor can start to act. They can start to sell assets, they can get rid of the car, they can distribute tangible personal property, they can look to sell real estate. There is a notice that gets published in the newspaper, and this notice is very important because it puts creditors on notice of the fact that if they have any claim against the decedent's estate, they have to file that claim within 3 months of the publication of that notice. If they don't come forward within that 3 months, they're then cut off. They can't come back against the estate, they can't come back against the executor, they can't come back against the personal representative. Now, important to note too, that if you are aware of a creditor that is out there, you do have to provide them with notice that does appear in the newspaper, but that's something that's usually coordinated through the attorney's office. So even though we've got this 3-month period of time that's sort of rolling until creditors file claims, that doesn't mean that we can't act during that 3 months. So if we're lucky enough, well, especially in this real estate market, if we can sell the property within that 3 months, we can go ahead and do so. The only thing that we can't do is distribute assets out to the estate beneficiaries. And of course, regardless of how we're proceeding, whether it's a supervised or unsupervised estate, we do need to have the personal representative keeping an accounting of the estate's assets.
Back to me?
Mm-hmm.
Okay. So, as Tim indicated, we do have obligations to creditors. We have to send mail notice to known creditors and publish notice in the paper for unknown creditors. So this is one of the reasons why it is more difficult in general for creditors to recover against assets that pass in a non-probate manner. So that TOD designation, that beneficiary designation, it's not impossible. There is a claims process in which a creditor can open an estate themselves and pursue and recover those non-probate assets. But just be aware of that for a client with creditor issues. There might be a goal in the planning process to have some or all the assets pass via non-probate. If assets pass in a non-probate manner to the beneficiaries, there is a 9-month drop dead deadline. 9 months from date of death, an ordinary creditor can no longer pursue those non-probate assets. That does not apply to certain governmental creditors. Tim's going to talk in a little bit about the Medicaid estate recovery process, so that is not what I'm talking about. But with respect to the Citibank Visa card or the hospital ER bill, if they don't do something within 9 months of date of death to pursue a non-probate asset, they are barred. So that is, if people receive assets via non-probate transfer, I tell them just sit on them for 9 months. Don't do anything, and then you're in the clear. And I also tell clients one really important thing. It is tough for me when clients come in and they have already paid some bills when they come in. Well, these bills came in, the Kohl's card came in from mom, so I went ahead and paid it. We don't want to do that. Creditors have to follow these steps. Once we notify them of someone's death, they have a legal process that they have to follow to file their claims, to validate their claims. Let that run its course. Advise your clients when someone dies, there's not a big rush to pay bills. The exception to that, though, is maintenance and security. If we've got real property, keep the lights on, keep it insured, keep the mortgage current. But with respect to the Kohl's bill or the Comcast bill or any of these things that are not necessary for maintenance and security of estate assets, don't rush to pay them. Bring them to us and we will deal with them. And that can be tough for people who've been used to paying their bills on time every moment of the day. They see that late bill come from Comcast and it's really hard not to pay it. And we get that, but it's really better to, like we said, let the claims process run its course. So, Next slide. So what if there's not enough money in the estate? What if the claims outweigh the assets? Claims are classified in Indiana in order of priority, and we've got the order of priority here. So it'll shock all of you, I'm sure, that attorney fees come off the top. Lawyers write the laws, so we have the luxury of writing them how we want them. But costs of estate administration, which is more than just legal fees, but it includes legal fees, come off the top first and foremost. Next is reasonable funeral and burial expenses. That comes off the top. Next is that $25,000 that Tim alluded to that goes to a surviving spouse or minor children. Next comes federal taxes, then comes expenses of the last illness, and then state taxes, and then everything else. So if you have enough money to pay classes 1 through 4, but then the expenses of last illness, there's not enough money to pay all those creditors, what happens then? Well, then you take whatever is left and you divide it equally amongst, or not equally, pro rata amongst whatever the creditors are in that next class. It is important to know that you do not inherit debt. If people come to me and they've been named as the PR in mom's will, and they're afraid that by getting appointed as the personal representative and administering the estate, they're somehow inheriting the debt. That is not how it works. There may not be any money to distribute. That's the reality. The debt can eat up the inheritance, but you don't actually inherit the debt. So we can ease people's minds about that. But to be honest, sometimes it doesn't make any sense to open probate. If everything is debt and the home is underwater and the car is, there's more owed on the car than it's worth and there's really nothing to collect, sometimes doing nothing is the right answer. I sat down with someone just yesterday and he said, does it make sense for me to open probate? And I said, no. I said, there's nothing in it to be gained. So, and that is something that it helps for us to work with the client to come to that determination. So a quick word. So once that 3-month creditor claims time period has run, we're ready to, all the assets are ready to be distributed, everything's taken care of and wrapped up. How do we close out the probate process? So Tim alluded to, you always have to prepare an accounting. No matter if you're in an unsupervised or supervised administration, you're going to have an accounting. With an unsupervised administration, you send that accounting to the beneficiaries. And you also send them the closing statement. And we just send it to the residuary beneficiaries, correct? Yeah. So we're not even sending, so if there's $10,000 to the church, for example, if that's been paid and taken care of, we don't send the accounting to them, but we send it to anyone who's entitled to share in the residue of the estate. And we send them a copy of the closing statement. At the same time, we file that closing statement with the court. The court waits 3 months. No one files an objection. It's done. Nothing else has to happen. In a supervised estate, the process is a little different and a little more complicated. The first step is filing the closing paperwork and the accounting with the court. The court then sets a date for objections to be heard, and the minimum period of time for those objections is 14 days, but it's probably going to be a little longer than that. And then if you want to speed this along and not have to deal for that objection period, you can get waivers from each estate beneficiary saying, we have no objections, go ahead and close this. And then at the end of all of that, the court will issue a closing statement. I would note this is one reason why unsupervised administration is typically preferable, because if you note with that final accounting in an unsupervised administration, you're only sending it to some of the beneficiaries. With a supervised administration, you're filing that with the court, so it becomes a matter of public record. So there's an element of privacy that's baked into the unsupervised administration that's not there in a supervised administration. Okay. So it is not, clients come to us all the time and they're absolutely convinced, they were talking to their neighbor Joe, that you have to avoid probate. It's the #1 thing that you want to do in Indiana. And that is not always the case. For some clients, it makes a lot of sense to avoid probate and it's great. But with some clients, actually probate can be a great centralized place. As Tim said, it's a place where disputes get resolved and things get clarified. It provides kind of a clearinghouse for things. If you've got everything in the estate transfer on death or pay on death, for example, so it's all going straight to the beneficiaries without probate, what happens if you've got 3 people who inherit a home via TOD deed, who don't get along. You've got some people who really don't want to be roommates who are roommates. So when parents come to us and like, we want to avoid probate and we want to make our house TOD to our 10 kids, you definitely don't want to do that. Even if it's just 2 kids, if they don't get along, you may not want to do the TOD mechanism. You may want to allow for probate. I had someone the other day who was talking about TODing her home to her 2 kids, but when I asked, how do they get along? Do you think they'll be able to work together to sell that property after your death? She kind of winced and said, oh, they don't get along very well. Well, then in that case, probate might be the answer, because she can name one of the kids as personal representative who can handle the sale, take care of all of that, and not create that situation where people are in conflict. And also, if everything is TOD or transfer on death or beneficiary designated or whatever, you might have liquidity issues. If you've got real property sitting in a probate estate, but all of the bank accounts were POD to people, where's the money going to come from to keep the lights on, to keep the mortgage paid, to keep the home insured while the probate pens? So that can be a problem as well. And also, it's not uncommon that one child might advance the funeral costs after death. And if there's not a probate estate, it can be kind of difficult determining how do they get reimbursed. If everything passed TOD to the siblings, guess what? The siblings might not feel particularly charitably inclined and want to reimburse their brother or sister for the out-of-pocket payment they made on the funeral. So again, sometimes probate is a great mechanism for this. Sometimes clients are set up in a way that we can avoid probate for them. It's a really fact-sensitive determination for each client.
You know, I would jump in real quickly,
well,
Kristen, as well. Well, yeah. But with respect to the slide that you got there, I would double check too, as Kristen's slide says, to take a look at the fine print. I've encountered some circumstances where a client filled out a POD or a TOD designation on a document, and if you read the fine print of that, it may provide that in the event that one of the beneficiaries passes away, their share is essentially removed and goes to the remaining beneficiaries as opposed to their children, which is probably what would happen under the terms of a will. So again, I mean, I think POD, TOD can make sense, but make sure that you understand and that your clients understand what it is they're getting when they complete one of those documents. So let's talk a little bit about Medicaid estate recovery. So there was a law that passed a few years ago that provided that in any case where the deceased individual is over the age of 55, that Medicaid is what's known as an ascertainable creditor. And so that then means that you are obligated to provide notice every single time that you open up an estate to Medicaid. And obviously, if you're going to send a notice to Medicaid of the fact that you've got an estate, they're going to file a claim, because Medicaid has a preferred claim for the cost of care that they've paid for the individual's behalf when that individual passes away. But if your sole affidavit, if your sole asset is going to be a piece of real estate, which for most of our Medicaid clients, that's going to be the case, then you really want to take advantage of that 5-month situation that Kristen was referring to earlier, either by the title transfer affidavit or by completing a TOD affidavit documenting the fact that the individual has passed away. So by proceeding in that manner, you've now turned the tide over to Medicaid. And if they want to do something with that particular piece of real estate, they've got to come into the county of residence, they have to open up an estate, and they have to do so within 5 months of the individual's death. So they have to open the estate within 5 months and letters of administration issued within 7 months. So again, that can be really to your advantage if you've got a potential Medicaid situation. And right now, honestly, we're seeing Medicaid estate recovery is all across the board. I know Keith Huffman in my office has had a few where they've made claims on real property. I've had others that have been frankly shocking that they haven't done that. So this seems to us, at least, to be the best way to proceed when it comes to real estate to avoid opening up an estate. We also occasionally will have these unusual situations where we know the client was on Medicaid, we know that they owe money to Medicaid, we've opened up an estate, we've sent notice to Medicaid, and they've not done anything. Well, we ultimately want to be in a position where we can conclude that estate and let everybody move on with their lives. So what we advocate in that situation, if we've got an unsupervised estate, flip that to a supervised estate. All the steps that Kristen talked about with the closing paperwork and setting that matter for hearing, that's what we want to have happen so that the Medicaid office gets notice of that hearing. And if they don't object to the closing statement or the proposed distributions that we're filing, then that's going to protect us going forward. Again, kind of an obscure situation, but does happen from time to time. What about taxes? I'm not sure that I've ever had an estate administration appointment where we do not get a question about taxes. So first category of taxes are going to be death taxes, and these are by and large a thing of the past. Indiana used to have its own system of inheritance tax, which was repealed in 2013. Federal estate tax is still potentially applicable, but that's only for individuals who have wealth in excess of $11.7 million. With recent changes in the tax laws, there's also this notion of portability. So surviving spouses can transfer their unused portion of the federal estate tax exemption over to their surviving spouse. And so you can now shelter under present law up to $23.4 million without having to be concerned at all about the federal estate tax. Now, this particular law is in a little bit of a state of flux. In 2026, that federal estate tax exemption is supposed to go back down to $5 million and index for inflation. And there's some word around Congress that they may come out with an even lower federal estate tax exemption. So you do want to stay tuned to those developments to see how that ultimately may impact your clients. But as we sit here right now, nothing has been passed, and so the present law is still good. Let's talk then about income tax considerations. And first of all, whatever assets that your client owns in their own name at the time that they pass away is going to be eligible for a step up in basis to fair market value as of the date of that individual's death. So this can be a great benefit to your clients and their beneficiaries, knowing that they don't have to worry about capital gains tax when they ultimately do pass away. And this is a question that we get all the time. In fact, I just got this yesterday. I made a family very, very happy by letting them know this. But by and large, an inheritance that you receive is not going to be subject to income tax. This family yesterday did not believe me. I threatened to go get a copy of the code section to show it to them to say, no, you are not paying income tax on the sale of the house, brokerage accounts, bank accounts, things like that. Now, the exception to this is going to be if the estate does involve assets that have never been taxed, like a retirement account, or if we've got savings bonds with a bunch of accrued interest. So those are going to be exceptions to the general rule. But again, by and large, what you do receive as an inheritance is not going to be subject to income tax. I don't like what the will says. How do I contest it? I would say I probably get this call probably about 2 or 3 times a year. This is something that you hear in movies, TV shows, things like that about contesting a will. But the reality is it's very difficult to contest a will in Indiana. And there are only 3 grounds to be able to do that. So number 1, you have to allege that the will was not properly executed. Well, if you're working with an attorney's office, that's hopefully very unlikely to happen. You have to allege that the will was the result of undue influence and fraud. And by that, I mean something slightly short of holding a gun to the person's head saying, sign this, or alleging that the person thought they were signing a birthday card for somebody when they executed the will. So again, very difficult to prove. Or that the testator was of unsound mind when the will was executed. And this is probably the one that's most common that we do hear about. But the reality is, the further away you get from the date that the will was executed, the more difficult it becomes to try to prove that that person was not of sound mind. I've had an occasional office conference with a person who complains about a will that was executed 10 years ago. Well, that's just next to impossible to prove that they didn't have capacity at the time that they signed the will. But the reality is it's very expensive to try to overturn a will by contesting it. And you always want to be mindful too of the fact that if you're invalidating a current will, then that means either a prior will is going to be the new will, or if there is no will, then we're going to the laws of intestacy. So you always want to take a look and find out, okay, if we do contest this will, what is the backup plan going to be? You need to keep in mind too that if you're going to contest a will, you've only got 3 months from the date that the will was admitted to probate to be able to do so. So So you have a very short time limit there. And this is something new as well. Under Indiana law, we now have no contest clauses, which has been allowable since 2018. So you can now stick in your will and it be recognized under Indiana law provisions that say that if a beneficiary contests the will in any way and they ultimately lose, then they forfeit any rights that they may have under the terms of that will. This can be particularly important if you're anticipating a challenge of your estate plan from a beneficiary. Maybe you take a look at sticking a sufficiently large gift that would dissuade that beneficiary from ever wanting to file a will contest action because they might ultimately forfeit what they otherwise would be able to receive. Back to Crystal.
Okay. So we also get calls sometimes from people, we're not administering the estate, but they've gotten the notice from the court, they're a beneficiary of an estate. They have no idea what's going on and what should I do? And in that case, that beneficiary needs to have their own attorney. The proper role of an attorney who's representing or who's handling the estate administration is the duty is owed only to the personal representative. So the attorney who's handling the administration, who's filing the opening paperwork and all of that stuff, does not owe a duty to the beneficiaries of the estate. So it's frequent that it's frequent that I'm representing a personal representative and there are several beneficiaries of the estate and they don't have their own counsel. And when everyone's getting along and nothing is being contested, that's normal. There's no need for every beneficiary to have their own lawyer. That's just way too many cooks in the kitchen, way too many lawyers. But if one of those unrepresented beneficiaries calls me with questions, I can't give them legal advice. I can answer factual questions about the estate. The will was admitted to probate on this date, our creditor date is that date, things of that nature, but I cannot give legal advice to that beneficiary. So if the beneficiary is having questions about the validity of the will or whether the estate is being administered properly, things like that, he or she is going to have to get their own attorney. To get some preliminary information, the status of an estate administration, even an unsupervised one, in every county is public record. Again, there's less information published with the court in the case of an unsupervised administration, but you can still get the basics. You can get when the estate was opened, you can get who's serving as personal representative, those sorts of things. And in the case where we really get the feeling that something suspicious is going on, there really is a strong feeling that the personal representative is not doing something properly. There might be some fraud. There might be some money that's not there that should be. There always is that option to petition the court to convert the estate to supervised administration, because then the personal representative has less autonomy and is supervised by the court more, is forced to show things to the court with more transparency, and hopefully prevent any loss of assets that shouldn't be lost. But in general, if a beneficiary of an estate has very basic questions, they can ask those basic factual questions of the attorney handling the estate. But if there's any sort of disputed situation, it becomes incumbent on them to have their own attorney. And we as attorneys ethically have to advise them of that. So I guess in closing, we've got a slide, probate myths, because these are some of the common misunderstandings that people come in to us with probate. The first one is that there's some sort of, we pay the state when we go through probate. That's not it at all. There's also, on a related note, people sometimes think if I don't have a will, the state takes a percentage, and that is also not the case at all. So just be aware that that's kind of a myth. The myth, probate takes forever. I would say on average, probate estates are, if they're not contested and people aren't fighting, 6 months probably is average. That creditor claims process is 3 months, and then a couple more months to wrap things up. And then the whole idea that probate is expensive. Do I want to go out on a limb and say, do I want to throw a number out there, Tim? Is that risky? I mean, people always want to know, well, what's it going to cost to go through probate? And to a degree, we can't answer that question because we don't know what can of worms we're opening. We typically charge by the hour. I tell my clients, if no one's fighting and there aren't a ton of creditors, so things are relatively simple, I mean, we're going to probably be in the $3,000 range for fees and expenses to take an estate through probate. It can be higher, of course. The more disputes there are, the more conflict there is, the more creditors there are, that complicates everything. And it's funny because the size of the estate in terms of the amount of assets really has nothing to do with what the cost of the probate is going to be, because it could be a very simple estate where everyone's getting along and be large, or it could be a very small estate where everyone's fighting. So really it's a fact sensitive determination. And I thought of what I was going to say earlier and I forgot, and it actually fits really well with this slide. So whether or not you have to go through probate for someone has nothing to do with whether they were rich or poor. It has nothing to do with the size of their estate, because as we indicated, a lot of those assets can go through non-probate mechanisms. So someone can die and be worth $2 million, but it was all in IRAs, which are beneficiary designated to, directly to their beneficiaries. Someone can die with $75,000, but it's all in a bank account, then we have to go through probate. So really we need to know more how assets are titled than how the size of the estate to know whether or not we're going to have to go through probate. So that's what I forgot to say prior. So that.
We'll give Brandy McAfee an opportunity to frantically rush up here with questions that any of you have.
I think she can break in without rushing.
She can break in.
She can break in, yeah.
Yeah, I sure can. So I guess one of the questions that we have here, I'll go ahead and read this off for you. It's from Haley. She's asking, federal estate tax. In your opinion, what is the likelihood of this to change to 5 ML earlier than initially stated in January of 2026? If likelihood is high, what are recommendations made to those clients who fall in the 5 million or more category?
Well, so Haley, I will freely admit I'm going to punt on this question until Thursday because I've got a webinar that I'm sitting in on with somebody, an expert out of New Jersey, through an organization that I'm a part of, to find out a little bit more information about that. And so once I do learn more, that's something that I would anticipate putting on our website in the form of an article. So give us a little bit of time on that and let us see what that ultimately looks like, and we'll get back with you on answers to that question. I realize that's a bit of a cop-out too.
No, but she said awesome, thanks. So we have your email address, Haley, so we'll make sure we let you know when that article is posted as well and get you some more information on that. I did have a question. So for the financial planners, when an individual comes into the office for them, let's say that they are the first point of contact after a loved one has passed away, is there a good set of standards for them to kind of follow? What are we needing from them as far as retirement accounts and things go? How many months or quarters worth is good for them to send along with their client to a meeting with us?
Did you answer that one?
I mean, I would say anything is a bonus. I mean, so often clients come in and we're working from very, very little information. I don't typically want anything that much precedes date of death by a month or so. I mean, that would be ample information. I'm much more concerned about the status of assets as of the date of death. Mm-hmm. So.
Agreed.
Anyone else have any other questions that they can think of? Feel free to unmute yourself if you'd like to ask something out loud. That's not a problem. We'll take those as
Going once, going twice.
Thank you for joining us today. We hope you have learned something new about estate administration and probate that you can use in your daily life as well as with your clients. A recorded video will be available on our website in the next few days. I wanted to make everyone aware we have had a slight change in the remaining 2 courses in our webinar series. Next week's presentation on Medicaid farm planning and digital estate planning has been moved to Tuesday the 1st. And then our series will wrap up with Keith and Michael Huffman on June 15th. So we do have some slight changes. You will be receiving an email reminder for that as well. If you have not registered for those and would like to do so, you can email us at events@dhblaw.com or feel free to give the office a call 260-824-5566. Otherwise, we thank you for joining us today. Have a wonderful rest of your day.
Thank you.